Today we have petitioned the Constitutional Court challenging the unbecoming conduct of judicial officers who purportedly exercise judicial power with impunity. Our petition is based on the events that happened during the new year, the new lawyer opening at the judiciary headquarters, where Counsel Ssekaana, the supreme leader of the Radical New Bar and the president of the Uganda Law Society, was blocked by the Chief Justice to address the country on matters pertaining the status quo. The president had gone to the judiciary headquarters not in his personal capacity, but as a Radical New Bar supreme leader and the president of the Uganda Law Society. However, during the course of business, the Chief Justice blocked him from addressing us. As lawyers, we overwhelmingly elected for Counsel Ssekaana Isaac to be our president, from whom we always expect accountability in form of public addresses. Counsel Ssekaana introduced the Chief Justice to us. However, when the protocol was being followed, the Chief Justice abrogated it and said the Ssekaana should not speak. He should not come to, he actually said, you cannot come to my home and abuse me and expect me to give you an opportunity to talk. So we are looking at the judicial officers using court premises as their homes, where freedom of speech is going to be curtailed, yet the same courts have oftentimes declared freedom of speech as that which includes offensive speech. So today we have sued the Chief Justice, Honorable Justice Owiny-Dollo Chegemoy, together with Justice Ssekaana Musa, who has been appointed to the Court of Appeal, and the Attorney General of this country, for the Constitutional Court to interpret whether the conduct of these officers is a violation of the constitutional provision, and if so, we are asking the court to declare the same as null. You shall realize that a number of times Justice Ssekaana has vehemently persecuted Ssekaana, the supreme leader of the Radical New Bar, in his personal capacity, but even when he comes before him as the head of the bar, is still prosecuted and persecuted. A number of complaints are at police, a number of complaints are before the law council, before this same court, the Chief Magistrate Court here at Uganda Road, and other disciplinary bodies. So being an ardent supporter of the Supreme Leader Ssekaana Isaac and his follower as the Radical New Bar president, I have this time round petitioned the court to come and condemn in the greatest term the conduct of our judicial officers. The courts have often said you can annoy the president. You have read Stella Nyanzi, you have read Andrew Mwenda and another versus Attorney General, and Andrew Mwenda versus Attorney General, where the courts have even outlawed some colonial laws that have made it impossible for Ugandans to freely express themselves. And for your case, Ssekaana, as the president of the Uganda Law Society, belongs to the school of thought that is the radical rudeness. Which school of thought believes in freedom of expression in terms of provocative mechanisms, to seek accountability, transparency, adherence to rule of law, of which most of our judicial officers are now seemingly having phobia for. That when Ssekaana uses a language that they are not happy with, they just issue ultimatums to him. So today we are asking the Constitutional Court to declare the prayer by the Chief Justice that Ssekaana must make an apology before Justice Ssekaana for offenses, complaints that have never been brought before courts of law, before disciplinary committees or bodies for adjudication. But he was condemned and heard. We are saying this motivated appetite to persecute Ssekaana in a manner that is unconstitutional should be declared null and void by our Constitutional Court. We are therefore asking the court, one, that this conduct is condemned. Upon condemnation, we are seeking that court bars all proceedings against Ssekaana that have been brought by the rule of law persons, by the persons that are phobia for rule of law. And so we are hopeful that the Constitutional Court will address our concerns, because when you move here and there, Ssekaana can no longer move freely, but the likes of Andrew Mwenda are able to move freely. The likes of Stella Nyanzi, who can say the president is a pair of buttocks, and when the Court of Appeal sat, it said no, the president is not immune to being annoyed. And so we want to see the judicial officers who claim too much than what they cannot take in, that they can be put in line to continuously uphold the rule of law. The judiciary will act expeditiously. This is a constitutional matter. We have no doubt that if anyone is interested in persecuting Ssekaana, they should have to draw reference to Constitutional Petition number 5 of 2025. By the way, we have not only filed this constitutional petition, we have also filed miscellaneous. We have filed a constitutional cause number 2 of 2025 arising from Constitutional Petition number 5, where we are asking the Constitutional Court to stay all criminal, civil, disciplinary actions that have been brought against the person of the Supreme Leader, Isaac Ssekaana, until when this constitutional petition is determined. So it is incumbent of them who want to persecute him that they will have to respect this constitutional order that I have adopted to take. Otherwise, the more we sit back, our country will go back to the dogs.